Have you ever wondered how far is too far when it comes to police interview tactics? In today's video, I'll cover deceptive interview techniques, the history behind limits on police interrogation, what the law says today, and I'll end it with some tips to keep in mind. I'm Steve Serbalik, and I'm a panel attorney with AsCops in Arizona. As always, this is a topic summary and not legal advice. If you have questions about your specific circumstance, make sure that you consult a lawyer. Before I even begin talking about interview tactics, note that the assumption for the purposes of this video is that the suspect was already read his or her Miranda rights and has agreed to waive the right to remain silent and the right to an attorney. If you have questions or would like a refresher about Miranda, check out the video that I did on that case and its requirements. But on to interrogation techniques. Centuries ago, it was relatively common for agents of the state to torture individuals under investigation in order to elicit a confession. Over time, this became less and less accepted by courts in both the United States and in Great Britain. And in 1936, in Brown versus Mississippi, the U.S. Supreme Court examined confessions under the Due Process Clause of the 14th Amendment and looked to whether the confessions were voluntary in dozens of state cases. The court held that violence and interrogation by police was, quote, revolting to the sense of justice, and said, quote, that the rack and torture chamber may not be substituted for the witness stand. This leads to the ultimate conclusion that due process required that interrogations must yield voluntary statements, and courts look at the techniques under a totality of the circumstances approach to determine if the interrogation was unreasonable or shocking, or if the accused clearly did not have an opportunity to make a rational or intelligent choice. Over time, this totality of the circumstances test has allowed courts to make some bright line rules. Police interrogations that involve actual or threatened physical violence against the suspect are per se unreasonable, as are interrogations that go on for unreasonable lengths of time or are conducted when the suspect is deprived of food or water or sleep to the point that the answers are no longer viewed as voluntary. But what about lying to suspects? Can police officers do that? Generally speaking, the answer is yes. In Frazier versus Cupp, officers lied about how strong their case was and falsely told the suspect that his cousin, who was with him on the night of the crime, had confessed. The court considered this deception as a relevant consideration as to whether the confession was voluntary, but that it was not, on its own, enough to show that the confession was involuntary. Additionally, it's common for officers to fake sympathy towards defendants, and courts routinely uphold confessions that occur in interviews where officers pretend to care about or to understand the motivations of the suspect. For example, in Illinois versus Perkins, the Supreme Court held that Miranda forbids coercion, not mere strategic deception. The court recognized that, quote, ploys to mislead a suspect or lull him into a false sense of security that do not rise to compulsion or coercion to speak are not within Miranda's concerns. Now, like most things, deceptions in interviews can be taken too far. Some courts have held that confessions are involuntary if the police actually fabricate supposed evidence and show it to the person being interrogated. For example, actually creating a fake bloody footprint and showing it to a suspect as if it were proof of guilt may go too far, while telling the suspect that a bloody footprint exists could pass muster. Again, the analysis here, when it comes to deception in interviews, is based upon a totality of the circumstances analysis. And finally, here's what you should keep in mind. It's okay to fake sympathy for a suspect, and it may be okay to misstate the evidence against the suspect during an interrogation. But be aware that actually fabricating evidence or engaging in overly coercive tactics could fail the totality of the circumstance analysis and get any confession thrown out, even if a suspect has waived his or her Miranda rights. I'm Steve Serbalik. Thanks for watching and stay safe out there. If you're interested in watching another relevant video, click up here. And if you'd like to subscribe to the channel, click down here. And then hit the notification bell to receive messages when new videos are posted. Videos are posted every Sunday at 5:30 p.m. Arizona time.